Okay, welcome back to part two, session two of day one of the Kentucky chapter IPMA-HR 2021 annual conference, HR and the New Normal, presented exclusively by ServiceNow. Hope you enjoyed the sessions this morning, the two sessions we had this morning. And again, we'll talk a little bit more about the links and how those will be saved as we finish up this session and go to the business meeting. But at this time, I want to go ahead and introduce our next speaker, and Mr. Mark Sipek. He's the Executive Director of the Kentucky Personnel Board, and he is a 1982 graduate of the Ohio State University College of Law. It's important that you say the, if you go to Ohio State, the Ohio State University College of Law, and to practice law in Kentucky in 1982. For 10 years, he was a staff attorney. For 7 years, he practiced in Louisville with Miller, Mosley, Clare, and Towns. And then for 10 years, he came to state government. For 10 years, he was a staff attorney for the Kentucky Department of Corrections, where I first met him. He then joined the staff of the Kentucky Personnel Board as their general counsel in 2000. And he was appointed executive director of the Kentucky Personnel Board in 2004, and he still serves in that role. He is a certified Kentucky Employee Mediation Program mediator, and during his career, he's argued 6 cases before the Kentucky Supreme Court, and he's also taught some employment law classes, courses at the Kentucky State University. So Mark, at this time, we'll turn it over to you for some updates from the Personnel Board, and you have the next hour if you want to take it. We also have, I'll remind people, if you have any questions, we have the questions and answer button there on the bar there, where you find that there. You can enter those questions. You can probably enter them throughout the presentation. Mark may answer them during the presentation, or may just wait till the end, and we'll go over those before he finishes out his program. So at this time, I will turn it over to Mr. Mark Sipek.
All right, thank you, Larry, and thanks for the opportunity to speak to IPMA today. Wanted to talk about some things that have occurred at the Personnel Board, obviously, over the last year. Since March of last year, all of our board meetings have been video meetings. In fact, thanks to our general counsel, Stafford Easterling, we recognized that we were going to video meetings a couple of days actually before it was mandated, and our March meeting of last year we did hold by video. We've gotten somewhat used to it. In fact, we had a board member, Demetrius Holloway, that we never met in person. He served only in video hearings, and then took another appointment which was incompatible with staying on the board and is now off. We never got a chance to meet him, but we did have several meetings with him. I know our board members are anxious to get back to meeting in person, and it looks like that's probably going to be happening fairly soon, and we'll see how that works out in terms of whether or not there will be any audience or any other participants in person, or whether it will just be the board. But so stay tuned to see how that develops. In addition, since March of last year, we've been doing all our evidentiary hearings by video. I think we did one by telephone. The parties agreed to that. For the first several months, we didn't have any hearings, but slowly we had people agreeing to do the hearings by video. And one of the unique features about our appeals are governed by KRS Chapter 13B, which allows for hearings to be done by what they refer to in the statute as electronic means, which includes video. But it can only be done if all the parties agree. And so I think early on, people didn't have an idea of how long this situation might last. We had a lot of people, either one side or the other was not agreeing to video hearings, and we were working out exactly how those were going to be set up. But as the pandemic continued, we had more and more people that have agreed to them, and we've had pretty good success with video hearings. They're a little more of a challenge than an in-person hearing. They require a little more preparation on everyone's part. and they require a lot more patience for everyone. There's a lot of things that are simple to do in person that sometimes when you have a video hearing going on and people are in several locations, it gets difficult. We continue to do all our pre-hearing conferences by telephone, and it looks like, as I said, we'll see how things open up here in the future. After listening to your last couple of speakers, I would say my anticipation is that in the future we probably will see some hybrid hearings. I think once agency and participants have gotten used to the ability to call certain witnesses by video, again, it's going to require agreement from both parties, but I think we're going to have that, and we'll probably have for a long time. We'll have some witnesses that will continue to appear by video. It seems to me it's a great opportunity to get some of those witnesses that were hard to get to an evidentiary hearing. We have a lot of former employees with turnover that takes place by the time a matter gets to hearing. A lot of times a key witness may be no longer employed with the agency. A lot easier to get that person to agree to a half hour of their time by video rather than coming to Frankfurt for a hearing. And I think that's probably something that's going to benefit both sides as hearings go forward. I'm going to talk today about some personnel board decisions. Keep in mind that the board makes those decisions, and that is how they speak through those decisions. I'm going to have some commentary on those cases. That commentary is going to be my own, and I can't really speak for the board. I think those decisions speak for themselves. And all of the cases that I'm going to talk about today either are on our website or will be on our website soon. And if they're not on the website yet, they are probably available using Westlaw. So if there's any that you're interested in, want to find out, can't find it on our website, you might ask one of your agency lawyers, and they should be able to locate it using Westlaw. In talking about recent cases, I thought a good place to start was really to get back to the basics, and a case to sort of illustrate that is a case of Tony Moore versus the Transportation Cabinet. This was a case that involved Mr. Moore getting a 5-day suspension. He received his disciplinary letter, which included this language. During the investigation, it was determined that while at work, you've utilized your personal cell phone, or the personal cell phone of Mike Price, the right-of-way agent supervisor, to send sexually explicit text messages to his wife. Both Price and Marcia Atwood, right-of-way agent 3, witnessed you engaging in this conduct. So it's a pretty specific charge, and it tells Mr. Moore what he did wrong and what he's been accused of. What the letter did not include was the date, time, or place that Mr. Moore was alleged to have used Mike Price's phone. Because of this, this letter did not fulfill the requirements of KRS 18A.095 parentheses 8. And at the hearing, Price testified that he told the investigator when and where the event happened. He said it was in May of 2016, and in fact, he was even able to get more specific than that. He recalled the exact date, stating that it happened, or approximate date, stating it happened shortly after his wife had gone on a Christian retreat. So I think there's a lesson there that and when I talk about the letter is that notice that an employee receives that they're receiving disciplinary action, in this case a suspension, and that's an important document and not just a formality. And really, if you think about it, with that letter, you probably can't win a case with the disciplinary letter, but you can certainly lose the case. And if you leave out one of the statutory requirements, like the date, that's one way to lose that case. I think over the years, the board has been relatively lenient on that issue. We've had a number of instances where there was an approximate date or a month or a time frame, and those have complied. This was a case where there was absolutely no date given, and then the witnesses that testified about the event basically said they knew the date. So that was a case the Transportation Cabinet lost, and that's why they lost it. Sort of keeping with the idea of going back to the basics, the next case I wanted to talk about is a case Vicki Sanderson versus Kentucky Department of Military Affairs. Sanderson was the area manager for Region 5, and which included Fayette, Franklin, and 10 other counties. The director of the Department of Military Affairs reassigned county assignments, and Ms. Sanderson was given 5 additional counties. She received notice that her work location was being transferred from Frankfort to Lexington. This change was made because Ms. Sanderson's supervised an administrative assistant who was assigned to Lexington, and it was determined that she required on-site supervision. And also it was determined that the Lexington Armory was more centrally located for oversight of the administrative duties and response. Now, Sanderson filed an appeal. She objected to this change, stating that she was a caregiver to her grandchildren and her father-in-law, and that the extra miles of driving to Fayette County from Franklin County, where she lived, were going to create an additional burden. She also argued that Lexington, Fayette County region had many resources available, and that her assistance was basically unnecessary there, and that she was more useful to stay in Franklin County. As it turned out, this case was not decided on any of those competing reasons for this change, and this was found in finding of fact number 8 in this case. It was uncontested that the only thing that changed when the appellant was relocated to the Lexington Armory was the address and location of her workstation. By all accounts, including the testimony from the agency's own witnesses, her position remained the same. And the hearing officer in this case found that this action was processed as an involuntary transfer. However, it didn't meet the definition of a transfer. The statute defines that a transfer as a movement of any employee from one position to another, and all the evidence at the hearing established that this was a change of workstation and not a transfer, and maybe more important than that, not just a change of workstation, but a change of workstation out of county, which is not permissible. And so citing a couple of regulations, 101 KAR 2095, Section 3, referring to workstation and temporary assignment, and then also 101 KAR 1335, talking about being able to assign an employee to a different work site only within the county. The hearing officer and the board found that this action was improper and overturned it. So again, this was not a case where the board said to the agency that they couldn't have done this. It just said that they didn't do it right in these circumstances. And in fact, the Department of Military Affairs, after losing this case, went back and properly transferred Ms. Sanderson from Franklin to Fayette County. She appealed that action and then dropped it while it was pending. But you know, the board certainly wasn't saying that agencies couldn't take this step, but if they're going to conduct a transfer, they have to make sure that it meets that statutory definition and in order to comply. And we've also seen some other cases that have had this issue going forward. So that is something that's out there. Sort of continuing with the idea of talking about just some basic ideas with appeals, talking about we continue to have cases involving appointing authority issues, and one that the board heard a while back was the case of Rhonda Kuiper versus the Labor Cabinet and the Kentucky Workers' Compensation Funding Commission. Ms. Kuiper was a non-merit employee who was dismissed without cause. She she served on the Kentucky Workers' Compensation Funding Commission. That was her place of employment. I think she was an auditor there. When she filed her appeal, she alleged age discrimination, retaliation, and wrongful termination. And there were a number of pre-hearings in this case, and it took a while to figure out that when Ms. Kuiper was saying wrongful termination, what she meant was that the person that fired her lacked appointing authority. And the letter that she received notifying her of her dismissal was signed by the executive director of the Kentucky Workers' Compensation Funding Commission, Reuben Jones, and also the HR director for the Labor Cabinet, Tiffany East. Now, with respect to Reuben Jones, the agency argued that Jones had an inherent authority to dismiss the appellant, citing the statute involved with this agency. And I may have written it down wrong, but I know it's, I think it's 324 1224. But this statute stated that the board of directors of the commission shall appoint an executive director and other persons to carry out the affairs and business of the commission, and also the board of directors shall fix the compensation of such persons. The hearing officer and the board read that section to pretty clearly give appointing authority to the board of directors and not the executive director. The board of directors for the commission certainly could have delegated that authority to Mr. Jones, the executive director. However, they did not, and that was not in dispute. Next, with respect to Tiffany East, and this was a letter that was co-signed by both of them. Ms. East was designated as an appointing authority for the Kentucky Workers' Compensation Funding Commission by the Labor Cabinet Secretary. And the hearing officer found, and again, the board agreed, that the Workers' Compensation Funding Commission was attached to the Labor Cabinet for administrative purposes only, and that the Personnel Board found that administrative purposes only did not include the authority to hire and fire. Now, Kuiper failed on her discrimination and retaliation claims, and when this case came in front of the board the first time, they remanded it back to the hearing officer because they wanted the parties to specifically address the issue as to whether or not the appointing authority analysis should apply to non-merit employees the same as it did to merit employees. And after hearing, I'm not sure if they took any new testimony. I think it was mainly just the parties filed briefs on this issue and cited their authority. The hearing officer made a decision that the appointing authority issues apply to non-merits as well as merit employees. And she cited, first of all, the definition of appointing authority, which is contained at KRS 18A-0051, is non-specific, doesn't reference merit or non-merit employees. And then also she cited the regulation 101 KR 3:050, which states that unclassified employees serve at the will of the appointing authority. Now, and this I picked up from our general counsel. His recommendation is when it comes to issues like the appointing authority, he recommends a belt and suspenders. So the idea is it may be redundant, but if you've got somebody like an executive director, or if you have somebody like the HR director for the cabinet and you want to make them the appointing authority who's going to take action in a particular case, the thing to do is probably take a careful look at the statute setting up the entity and figure out all the possible people who could be found to be the appointing authority and have them all designate the HR director or the executive director or both as appointing authorities, and then that issue doesn't come up. The important thing, though, here is that this is an issue that has to be decided well in advance of taking action against an employee and certainly well in advance of a hearing. These are things that are important to have have thought out ahead of time, and also to think about critically, not just to come up with an argument, which the agency did. They had an argument that the executive director had this inherent authority, but it wasn't a very good argument, and certainly neither the hearing officer or the board agreed with it. Now, this case sort of went on from here. The board found that neither of those people had appointing authority. Ms. Kuiper won her appeal and was ordered reinstated to her old position. The cabinet filed an appeal to Franklin Circuit Court, but that was dismissed on some procedural grounds. Thereafter, the parties reached a settlement agreement whereby Kuiper did not want to return to her old position in return for a lump sum settlement. And while her appeal was pending, she'd obtained a merit job with another agency and was not interested in returning to a non-merit position. This is another trend that we're seeing lately, which is obviously we're seeing cases settled at all the time, but we're seeing more and more cases that are being settled after having been fully litigated at the board, and sometimes after appeals have been pursued either to Franklin Circuit Court, maybe the Court of Appeals and beyond. And we've certainly found that the folks at the Personnel Cabinet have worked with the parties to come up with creative settlement agreements, just like they did here in the Kuiper case. Certainly, the board encourages parties to explore all settlement possibilities at all times during litigation. We're seeing, as you're probably aware, there have not been a whole lot of standard mediations during the pandemic, but we're seeing settlements with and without mediation. And I know Larry's continued to do his best to work with the parties. He's worked with them through email to try and settle things. We've tried to, at the board, Stafford and I are both certified mediators, and we've done some video mediations. I think Stafford's probably been a lot more successful with those than I have, but we have seen some cases settle there. And we've also sort of had some, even when we didn't end the mediation session with a settlement, we've had cases where the parties were on the road towards settlement and then continued those discussions and were able to settle things. I imagine a lot of these things are well known to agencies, but I just wanted to mention some of the more common ones that we're seeing that parties are using to settle cases. We have a lot of folks that appeal from probationary dismissals. A lot of those cases get settled by lifting the ban on future employment. We have a lot of dismissals of all kind, whether probationary or status dismissals, that are settled by converting to a resignation. Sometimes those are done as resignation with, most of those are done resignation with prejudice, so the person doesn't come back. And sometimes they're with or without any added incentives or sweeteners, such as providing the person the annual leave or not. Now, the board doesn't judge, as a general rule, doesn't judge whether those are fair settlements or good ideas. The idea is, if the parties reach a settlement and it's legal, settlements are usually approved. And the idea is that we require somebody, obviously, with appointing authority to sign those settlements. And so the idea is they're in the best position to judge what's best for their agency, and obviously the employee, with or without counsel, is in the best position to decide whether it's a good settlement for them. We're also seeing some settlements that in various situations that involve back pay, and some that involve partial back pay. And a lot of times, some employees' main motivation in getting the case resolved might be to reach a particular date, and that may be for retirement purposes or otherwise. So those are just some things to keep in mind. There are a lot of possibilities out there with settlement, and certainly settlement is a lot more flexible than waiting for a hearing officer and board to make a decision in a case. There, you're going to get dictated the result to you, whereas through the settlement process, both parties can work out an arrangement that works for both of them. And we certainly encourage that, and that certainly is something that helps us with our caseload. I think the delay on cases would be much greater if we didn't have cases that were settled. I did want to point out the Kuiper case is about the appointing authority issue. We did recently learn that there are some limits on that appointing authority issue, and really any issue, and there is some finality to this litigation process. And we learned that in the recent Kentucky Supreme Court case of Perry Puckett versus the Cabinet for Health and Family Services. And this is a case that's been going on for 10 or 11 years. It's been it's been to the Personnel Board twice for hearing. It's been to various courts up and down, and ended at the Kentucky Supreme Court with a reported decision. And the bottom line is this, that if there's an issue such as did the person who take the action have appointing authority, that issue has to be raised while the appeal is pending at the Personnel Board. And in this case, it was raised for the first time while the case was on appeal to the Franklin Circuit Court. And at the end of this litigation, the Kentucky Supreme Court said that was too late. And I think this case has important implications for everybody involved in cases, because the important thing to remember here is that with Personnel Board appeals, unlike some other administrative actions, there's no provision that allows for reopening a case or continuing a case based on the concept of newly discovered evidence or substantial injustice or anything like that. So when a Personnel Board hearing is over, there is appeal to Circuit Court and the Court of Appeals and the Supreme Court. But the record and the issues are what was raised in front of the board, with some exceptions. And obviously there are some issues that can always be raised, such as jurisdiction and things like that. But I think the significant thing to learn from the Perry Puckett case is that there is sort of an end to litigation, and new issues can't be raised throughout the process. All right. The next case I wanted to talk about is a case where I was the hearing officer, and it's the case of Kristen Miller versus Education and Workforce Development Cabinet. Miller was a vocational rehabilitation counselor who was fired for lack of good behavior, and that included some comments and actions towards her coworkers and poor work performance with respect to her casework, which was the main focus, I believe, of the dismissal. She failed to enter 15 cases into the case management system within 7 calendar days as required, and this was like a continuing trend for her. She also failed to prioritize cases for Social Security and SSI recipients, which generally are viewed as pretty easy cases to determine eligibility and should be done quickly. And then lastly, well, there's a couple other things. One, she had an eligibility extension, which is required to be signed for by the consumer, and she didn't get the consumer's signature. She just sort of granted herself an extension, and this was in one case, and then she had several where she was beyond the 60-day decision-making period. And at the hearing, Miller did not contest the poor work performance. She claimed that her poor work performance was the result of being a victim of sexual harassment. She alleged sexual harassment by an influential coworker who was not a supervisor, but she claimed he had some important role to play in the agency, and he'd helped her out in the past. She alleged he'd made numerous sexual advances, including asking her for oral sex. Now, Miller filed this appeal without an attorney and then hired an attorney as the case went on. When she initially filed the case, she did not allege sex discrimination. She alleged retaliation for having reported sexual harassment. The problem with this, as was proven at the hearing, was that the investigation into her poor work performance had been going on for several weeks before she ever came forward with any kind of complaint. So it was really, there was no way to prove that this was retaliation. She did not report anything until after she received her intent to dismiss letter, and she really didn't provide any details regarding sexual harassment until her pre-termination hearing. Now, an interesting issue with this case is how to handle this claim, because factually she was testifying about being sexually harassed, but that really wasn't one of her claims. And how do you weigh that in terms of whether or not there was just cause for firing her for her admitted poor performance? The first thing that I did after hearing all the proof was to make a finding of fact that the appellant failed to prove her claim of sexual harassment. And the reason I found this was that she gave different versions of the harassment and what the events were that took place at her pre-termination hearing, to her therapist who testified on her behalf, and at the evidentiary hearing. I think it would have been a much more difficult case had she proven that this sexual harassment took place, and then she had her therapist who testified that she suffered from PTSD and that this could be the result of that harassment, and that it could impact her work. One of the reasons I thought this case was important to talk about, though, and something that I think everyone can learn from this case, is how the Education and Workforce Development Cabinet handled Ms. Miller's allegations. Despite the fact that these allegations came at the time of her pre-termination conference, the cabinet obtained a waiver from Ms. Miller in terms of the timeline to make a decision on her dismissal, and conducted a full and fair investigation of her allegation. This included placing the employee she was accusing of harassment on investigative leave. They tracked down all the leads and potential witnesses raised through Miller's report of harassment and statements from other witnesses. In the end, they concluded that these allegations were not substantiated, and they followed through with her dismissal, and it was upheld by the board. Even with that, however, they went beyond that. There was some admitted testimony that this gentleman that was accused of harassment, while there was no proof other than Miller's allegations that he had sexually harassed anyone, he did have a habit of hugging his coworkers at work. It was not viewed as anything sexual. Many of them were not offended, but the cabinet, after learning of this, took him off of special investigative leave, allowed him to return to the workplace. However, they gave him a pretty substantial warning to stop hugging his coworkers in the workplace. Just seemed like a case where the cabinet handled things correctly, handled the disciplinary action correctly, and handled the report of sexual harassment correctly. And I think a lot of times there could be a tendency, especially when someone raises a complaint like that at the last minute, just as they're at their pre-termination conference, to not give it much credence. But I think the cabinet did the right thing by doing a full and fair investigation here. All right, the next case I've got is this is sort of a short situation. This is a case of Nicholas Bush versus Transportation Cabinet. Bush was reverted from his position as a Highway Technician 2 to his former position as a Highway Technician 1. He was serving a one-year promotional probationary period. And he stated that his reversion was for his failure to complete a training class. Mr. Bush stated that he did not complete the class because he was not scheduled to take it until after the completion of his probationary period. He alleged he didn't control the schedule and that classes were scheduled by other staff members, and that in fact some of the classes were canceled due to the pandemic, etc. The Transportation Cabinet did not contest Bush's allegations and filed a motion to dismiss, stating that he did not allege any form of illegal discrimination. The motion to dismiss was granted and the appeal was dismissed. And the Personnel Board dismissed this appeal. They had some serious discussion, though, and really felt like Mr. Bush was treated unfairly. It's possible if this matter had gone to hearing, the cabinet may have had other reasons why Bush was reverted. But this is really just a note of caution. There was a dissenting vote from a board member under this fact pattern, and it certainly appears to be an action that's bad for morale. If you're having people that aren't meeting, not making it off probation because of a training class that they had no chance to attend. And we certainly hear from folks and from agencies that argue correctly that the personnel board is not the fairness board, and there was nothing the board could do to correct this situation. But certainly, it seems like agencies should try to treat all their employees fairly, and if there is a way to work around something like this training issue during a probationary period, that certainly seems like it would be a good idea. The next case I wanted to talk about, this one goes back a little ways, but this was an interesting case, and it took some while for it to finally resolve. This was Lisa Craigmile versus the Department of Corrections. Ms. Craigmile was injured when an air conditioning unit, window air conditioning unit, became dislodged and blew across the floor near where Craigmile was standing. This occurred at the Kentucky State Reformatory. Ms. Craigmile believed the unit struck her right arm or shoulder, and she went back to her work area, informed a coworker that her arm was hurting. When a supervisor learned of the incident, he filled out a workers' compensation form for the appellant to sign and insisted she go and receive medical attention. Ms. Craigmile was examined and diagnosed with deltoid and humerus contusions to the upper arm. She returned to work afterward that same day, but was told by her supervisor to go home due to her injury. In the meantime, the Internal Affairs officer reviewed the surveillance video of this incident, which appeared to show that she was not struck by the air conditioning unit. She came in the next morning. He questioned her and told her he believed she had committed insurance fraud by falsely claiming a workers' compensation injury. Later in the day, Ms. Craigmile met with the warden, who told her the same thing, that they believe she was committing workers' compensation fraud. She was presented with a voluntary resignation form to sign in lieu of termination. During the meeting, she was led to believe that charges of insurance fraud might be pursued, so she signed the resignation form. Misdemeanor charges of fraud were later filed in the Oldham County District Court based on the affidavit of the Internal Affairs captain, and those charges were later dismissed. At no time did the Internal Affairs captain or warden review the appellant's record, and I don't think they were aware of the sequence of events where it was not the appellant claiming workers' comp, it was not the appellant going to the doctor, it was her coworker and supervisors who encouraged her to do all those things. In any event, after her resignation, she hired a lawyer, filed an appeal to the Personnel Board, and alleged that her resignation was not voluntary, given all the circumstances. And after a hearing and hearing all of that evidence, and including watching a video of the incident, the same one that the Internal Affairs officer relied on, the hearing officer at the board believed that the appellant's resignation was not voluntary and was submitted under duress. Craigmile's appeal was sustained to the extent that her resignation was rescinded and she was reinstated to her previous position. Corrections wound up appealing this case to the Franklin Circuit Court. However, the case was settled while it was pending in Franklin Circuit Court. And I believe this was another one where, in the meantime, Ms. Craigmile found new employment, and the parties were able to reach a settlement that was satisfactory to all sides. It seemed to me, if there was anything to learn from this case, it was just that, and even though it was a resignation and not a disciplinary action, the agency sort of gave Ms. Craigmile this choice without really having knowledge of all the facts and being aware of this situation. And I think anyone who heard all the facts would not come to the conclusion that this was workers' compensation fraud. And in fact, there really wasn't any value to any workers' compensation claim that would have come out of this. So they were really left with an extremely weak case and lost in front of the board and then eventually settled. I have talked a little bit about settlements, but I wanted to go ahead and talk specifically about one that the board approved recently. It was a case of Christopher Helton versus the Department of Education. The reason I'm mentioning this, I believe, was a case where the agency went above and beyond normal practices to enter into a settlement agreement with Mr. Helton. He was dismissed from the Kentucky School for the Deaf while on initial probation, and they agreed to settle his claim, stating he'd be eligible to be certified on future registers for positions with the Kentucky Department of Education and the Kentucky School for the Deaf. The agency counsel prepared a draft of the settlement agreement and forwarded it to the appellant before a pre-hearing conference so he could ask all the questions he had regarding this settlement. Now, Mr. Helton was deaf, was speaking at these pre-hearings through an interpreter. He was not represented by counsel. He had a number of questions about the settlement agreement, and Ashley Lant, the attorney from the Department of Education, along with help from an HR representative, did their best to answer all of his questions, eventually got him comfortable signing this settlement agreement. He signed it. It was approved by the board, and these were not things that they had to do, but they were able to resolve this appeal in a fair situation. And they certainly made clear to Mr. Helton they weren't agreeing that he would be hired in the future. They were just agreeing that he could apply for those jobs in the future, and that seemed as like a fair outcome for all concerned. All right. The next case I have to discuss is a case that was just decided by the board at its last meeting. That's Arthur Johnson versus Kentucky State Police. Mr. Johnson was dismissed from his position as an Administrative Specialist 1 with the State Police for being under the influence of drugs at work. KSP at the hearing relied on the testimony of Lieutenant Blanton, who stated that he observed Johnson that day at work, that Johnson was agitated, his speech was choppy, his eyes were bloodshot and watery. Blanton wound up giving Blanton, who was a lieutenant and previously had obviously worked in the field, gave Johnson a field sobriety test. Significantly, Blanton did not testify about the results of the field sobriety test. He did testify that Johnson told him he was addicted to methamphetamines. Johnson was offered a blood test, which he refused. He was offered assistance with a program the state police have called the Angel program. He also refused. Blanton wound up driving appellant directly home. And after further action, obviously Johnson was fired and filed an appeal to the personnel board. Now, when Johnson testified at the hearing, he stated that day he was upset at work and had been crying. He stated he had taken a Sudafed and was not feeling well. And he also stated that he was a stutterer, and that although Blanton was his second line supervisor, they did not have much one-on-one contact before that date, and he didn't think that Blanton was aware of how bad his stutter was. Johnson denied that he admitted to being addicted to methamphetamine, stated that he did admit to occasional use of marijuana. Most importantly, Johnson denied being under the influence of any substance while at work. At this hearing, the hearing officer found that KSP failed to prove that Johnson was under the influence while at work. Now, I think going into this, they were relying on two things. One, which was the field sobriety test, which it turns out Blanton didn't testify about. So the hearing officer and the board never got the benefit of what the findings were. And secondly, they relied on Johnson's admission that he was addicted to methamphetamines. Well, Johnson denied that he ever said that. And I think what what probably was clear to the hearing officer was that whether he was under the influence or not, or whether it was his stuttering, that Johnson and Blanton were not communicating very well that day, and it's not clear what Johnson said to Blanton or what Blanton understood Johnson to say. Now, the hearing officer recommended that Johnson be put back to work and found against KSP. They filed exceptions and argued this case at the board and argued that the personnel board should not ask the Kentucky State Police to employ someone who's admitted to breaking the law through using drugs because of the nature of its mission. But I mean, in the end, the state police lost this appeal to the board because they failed to prove the allegations that they had made against Johnson. They didn't fire him because he had broken the law. They fired him because they alleged specifically that on a particular date, he was under the influence of drugs while at work. And when their evidence was presented at the hearing, it didn't convince the hearing officer or the board that he had been using drugs. As I said, the board just decided this case. It would not surprise me if the state police appeal this to circuit court. I think the court probably will uphold the board. They could change the outcome here, but I think this case really didn't have to be that hard. And I don't know whether Johnson was under the influence of drugs that day or not, but it seems to me the employer could have done a number of other things that day to make sure they had proof when they came to the hearing of his condition. Certainly Blanton could have testified about his specific findings with respect to the field sobriety test. They could have had more witnesses available, obviously could have used video or any other type of recordings. And if they believed that Johnson was making certain admissions, they could have had him either write out those admissions or make a recorded statement of exactly what he was admitting to. All right. I've got a couple of quick cases to go over. The next one is Lowell McGowan versus Department of Agriculture. This is a case that agriculture has won. They fired Lowell McGowan for a low evaluation. He received a 147 on his year-end evaluation. And I believe it's 149 and below is the unacceptable, resulting in either dismissal or demotion. Agriculture put on a pretty solid case here. The case is currently on appeal to the Franklin Circuit Court. One of the reasons I mention it and mention it quickly, though, is that during the year, there was an internal investigation that raised some concerns that McGowan was not accurately reporting his work time. He was a field employee, had a state vehicle with GPS. There were all kinds of discrepancies in his GPS records. There were days where his vehicle didn't move and he reported a full day work and sometimes even requested comp time. And then there were other days where he didn't work and he was using his vehicle, which obviously wasn't authorized. For whatever reason, when that was found during the year, the agency determined their proof wasn't strong enough. And while they initially considered dismissing him for that, they only gave him a written reprimand. And the only reason I point this out is they won at the board. The case is currently on appeal to the Franklin Circuit Court, but this is a risky case because his dismissal hinges on this rating of 147, which if the appellant gets 3 more points, he's no longer fired. And so they have to prove essentially every aspect of his evaluation to make this case. And it just seems like if they had, even if they didn't think they could dismiss him for the GPS issues with his truck, I think if they had taken stronger disciplinary action there, they might have put themselves in a stronger position at this point. They may still win the case anyways, but this seems like a difficult one. The last case I have to mention, Robert Coates versus Department of Corrections. This was a 15-day suspension. Coates was in charge of an inmate. This was at the Green River Correctional Complex. They opened a cell door, and in this particular unit, the inmate was supposed to be restrained. Coates left the inmate unrestrained. Nothing happened, but the incident was caught on video. It was a clear violation of policy, and the agency established that. Now, Coates, his defense was he'd been there for 12 years. He'd seen other correctional officers open doors and get lighter sentences. And at some point in the past, it had been all right to open the cell door without having the inmate restrained if you directed the inmate to stand against the back wall. This suspension was upheld by the hearing officer and the board. And one of the reasons I mentioned this case, the outcome is not that significant, but this was the board's last in-person evidentiary hearing. We conducted this one on March 11th of 2020. And after that, all of our hearings have either been video and, as I said, the one telephonic. So those are the cases I had to discuss today. And I think we're right around the time when, if there's any questions, I'd be happy to entertain them.
No questions at this time. Our attendees, if you want to send a message, question, please do so accessing your question answer icon in your menu options.
Okay, thank you, Mark. I don't see any questions and answers. Those are some cases that I was familiar with most of those cases, but it's always good to hear the perspective there. And having served on the board, and just when you think you've heard it all and seen it all, you haven't. And I always say that in state government, that you never know what's coming in that next case there. So thank you for that update. We have not had you at the IPMA conference for a few years now. And so we used to have, we tried to have an annual update. We haven't had you for a few years. So it was good to hear about that and what the board is doing in this new normal, as we call it, as we move forward. And so thank you for that presentation. If we don't have, I don't see any questions. So at this point, I will, Rebecca Ogden, are you available here for a door prize or two?
Yes, I'm sorry, Larry. I had a phone call.
That's okay. You know, life happens, business happens. If you don't mind, why don't we give away two gift cards before we start the business meeting? All
right, sure will.
Okay.
So last night, the firm of Cannon and Nelson identified and authenticated the drawings. For the first gift card, it is Rick Davis with the personnel cabinet. Yay, Rick. And then the second gift card is Jennifer Hart with the Board of Nursing.
Okay. All right, thank you. Well, I can speak for Rick. He doesn't need that Amazon gift card, so you can just go ahead and give that to me. But we will come back after the business meeting, and we have two more gift cards today, as well as a overnight park stay. So we'll do that as well. Okay, so if there's, at this time, we're a few minutes early. I'll go ahead and get started with the business meeting. I know we're virtual, but I do have the gavel if I need it. And we will slam that gavel if we have to. Just want to thank everybody this morning. I want to thank, obviously, the speakers in the first session and Mark for that presentation. I will remind everyone that after the sessions, the links that you go to into our agenda for each session will turn into videos to view later, and they'll be active for a few months. So if you miss a session this morning, or if you missed Mark's session, or if you just want to rewatch it again, listen to it again, you can do that, okay? So let me go ahead and get started with the business meeting, and I'll call this to order. So this is business meeting, what I'm calling business meeting number 1. This is where we'll cover most of the business that's required by bylaws. And then tomorrow we'll have a separate business meeting in which we'll give out the Gaddis Award. So I just want to thank everyone for attending the sessions here. I know everyone has work to do, and we've had well over 100 people on each session this morning. I think we'll have even more tomorrow. I've had some people that couldn't make it today, but they said they would make it tomorrow. So we're happy to have that again for our sponsor, Service Now. I want to start out by thanking the board of directors this year. We had it was an unusual year. All of our sessions this year were virtual. And although some people think virtual may be easier, other people think virtual is a little bit more difficult. Just making sure you get your speakers lined up and everybody is speaking, and making sure you're not muted and you got your camera on and all those good things that we have to do. So just want to thank all the board of directors this year. I mean, obviously Renata Simmons, we're going to talk about her. She's president-elect. Elena Myers, this is a immediate past president, so this will be her last meeting, and she'll be doing her 3-year stint and leaving the board on July 1st. Michelle Barnes, secretary, done a great job with communications. We've been sending those out, and Robbie's been doing the social media aspect with the Facebook and LinkedIn. I'm sure you've noticed that. Rebecca Ogden, of course, the treasurer for several years, always keeping everything in order and in line, and listening to me when I have requests like how much money do we have and things like that. Emmanuel, who's a membership coordinator, he was on the board this year. Proud of him and happy for him to be serving the board. Anitra Williams was our elected member at large, and so she did a great job, and she was actually instrumental in getting our first speaker in the morning, Dr. Corey Hicks. And then Robbie Perkins, he's the appointed board member. I appointed him to serve in that role, and I added IT Guru, and I'm surprised he didn't take that out, but it's still in the PowerPoint there. So, and he's done a great job of producing and getting all these live events going. And again, everything this year has been virtual. So just want to thank the board for everything they've done this year in doing that. I want to thank the chapter members. Because we're HR people. We like to get together. We like to talk. We like to have snacks. We like to mingle. We like to do things like that. And we haven't been able to do that. So happy for the board members, happy for the chapter members to come to the events and stick with us this year. Things will get better. And so happy for that. At this time, we'll start the old business. And so we'll go to the secretary's report, and I'll call on Michelle Barnes for that presentation, that report.
Thank you, Larry. It's nice to have everyone with us today. I emailed out the winter minutes this morning right before. I think I sent them out about 8:45, so you guys can pull up that last email. They are attached. The Kentucky chapter IPMA-HR held the 2020 winter business meeting on Thursday, December 10th, virtually. President Larry Gillis called the 2020 winter meeting to order. Larry welcomed the attendees. Larry called for review of the minutes for the 2020 fall meeting. Rebecca Ogden, treasurer, read the treasurer's report. Robbie Perkins thanked the Kentucky IPMA board and membership for supporting the 2020 lead conference and provided details about the conference. There were over 1,000 attendees, and a training credit was awarded for those who attended. The benefit for IPMA is that sponsoring the conference provides Kentucky IPMA with new membership. Larry introduced the Holiday Charity Spotlight for 2020, which was the Kentucky Employees Charitable Campaign. Larry announced the spring meeting would be held virtually, and here we are at our annual meeting, and adjourned the meeting. Back to you, Larry.
Okay. Okay, thank you, Michelle, for that report. Thank you, Michelle, for the report. As you know, we are virtual, and in this platform we've been talking about, everyone doesn't have their mic on. So, you know, we're trying to follow the bylaws and go there. We do have the question and answer box. Obviously, that's communicate if it needs to, something needs to be communicated. At this time, I will entertain a motion to accept the secretary's report.
Move to accept.
Okay, we have a motion to accept. Do we have a second?
Second.
Okay, we have a motion and a second to accept the secretary's report without objection. It's so ordered, so it's been accepted. At this time, we'll move on to Treasurer Rebecca Ogden and let her update us on the status of the Treasury.
Thank you, Larry. Our balance as of the end of the winter meeting on December 9th was $12,511.56. We experienced expenditures of $3,558.90. We had deposits of $5,091.10, giving us a balance at the end of yesterday as $14,043.76. Back to you, Larry.
Okay, thank you, Rebecca. And we'll have a few expenditures left after this conference, but not many. So we're actually going to end the fiscal year in very, very good shape. At this time, I will entertain a motion to accept the treasurer's report.
Move to accept.
Moved by Robbie Perkins. Do we have a second?
Second, Michelle.
Okay, we have a motion and a second to accept your treasurer's reports. So without objection, that's so ordered. So we have accepted the treasurer's report. At this point in the business meeting, our bylaws say that on an annual basis that we should establish an audit committee, or in this case, a person, because we didn't have a whole lot of expenditures this year, but in the past he's had a committee. So we've asked Mr. Stan Salchi to do that this year. He's done this several years in the past, and I believe he's been mic'd up and ready to go. Stan, if you're available, you'll need to show your video and open your microphone. And for the audit report.
Can you hear me?
I can.
Okay. Thank you, Larry. An audit has been completed of the financial operation of the Kentucky chapter of IPMA for July 1 through June 30th of the 2019-2020 fiscal year. The audit report for 2020-2021 should be completed at the next meeting. Upon completion of the audit, the balances, including deposits and expenses of the books of IPMA Kentucky chapter, appear to be in order with no major errors or omissions. A couple small concerns. Receipts for transactions need to completely be included. I think there was one or two missing. In most activity months, individual deposits had no clear breakdown. And then past recommendation, the attendees payment spreadsheet, event profit and loss statement, and the transaction reports were not completed this year. Recommendation is to reinitiate the attendees payment spreadsheet, event profit loss statement, and the transaction report, and then a clear breakdown for each individual deposit, including square space. That concludes the report, Larry.
Oh, okay. Thank you. Thank you, Stan, for the report. Glad to hear everything's in order. Always appreciate the recommendations. If we'll get those in writing from you, we'll turn it over to the board of directors, always trying to improve the way that we document the business. It is 19 to 20. 2021 won't be actually included until next year because we're still in the fiscal year until the end of June. That's why Mr. Salchi couldn't do that, but very good report. At this point, I will I will take a motion to accept the report and the recommendations of the audit committee.
Motion.
Okay, motion. Do we have a second?
Second.
Okay, we have a motion and a second to accept the audit report and the recommendations. And without objection, that's so ordered. So we have accepted that. The next part of the business, I just want to talk real briefly. I don't have a whole lot to say here about the southern region. I just want to mention that about 3 weeks ago, they had their annual Southern Region Conference. It was virtual, and by my count, the Kentucky chapter was again well represented. We had about 30 people attended the Southern Region. We always have a good turnout at the Southern Region. This was actually, the Southern Region was actually the only region of the 4 regions that actually had a live conference last year. We actually had it the week after we did the Castle, and was able to get that in right before everything kind of shut down. And all the other regions had to do virtuals last year. So this year, all 4 regions are doing virtual, and we just had that, and we had about 30 attendees, and so that was a good turnout there. I will say that next year, of course, the Southern Region is hoping to have an in-person conference, and their plans is to have it where they were going to have it this year. If everything goes as planned, it's going to be in New Orleans, Louisiana. I think we went down there in 2012, 2013, I think 2013 maybe, and had a very good conference there. So that's going to be the plans for next year if everything goes as plans there. And finally, just real briefly about the Southern Region, they at the business meeting, they elected me to be the executive council representative. Each region gets 1 representative on the executive council, and so I accepted that nomination there. This is actually going to be a pretty good thing. I was on the executive council a few years ago on the national level, but this gives me a seat on the Southern Region board. So we'll have a little bit more insight about what the Southern Region is up to. So as well as the national. So that's a good thing that maybe in future meetings I can provide some information on that. Okay. Next, we'll move on to the nominations committee. As you know, end of June, we end this year, and so the new board members will be starting July 1. Mr. Senior Buchanan was the nominations chair, and he was assisted by Mr. Galen Linville. Singer is not able to be with us today, and I didn't think Galen was going to be able to be with us today, so I agreed to handle the nominations here. We do have 5 seats up for election. We have, of course, president-elect, and we have treasurer, and we have secretary, we have member-at-large, and then we have membership coordinator. And of course, Renata Simmons is president-elect. She will ascend to be president, so that's not an elected position this year. So we have 5 positions up for nomination. An election, and I think I have a slide that shows the 5 members that have been nominated. We have Mr. John Ostrowski for president-elect, Michelle Barnes for secretary, Rebecca Ogden for treasurer, Anitra Williams for member-at-large, and Tanya Lawrence, personnel cabinet, for membership coordinator. In accordance with the bylaws. At this time, I will entertain any nominations from the floor. And again, that will have to be through the questions and answer mechanism. Okay, do we have any?
Yes, there's been a floor nomination to add Grover Dale Clemens to the ballot for president-elect.
Okay, so there's been a nomination to add Grover Dale Clemens as president to the president-elect election, right? Any other floor nominations received, Robbie?
None at this time. Let's give a few more seconds. Attendees are on a 20 to 30 second delay.
Okay. Okay, so,
Nothing else.
all right, so we've had one nomination. So 2 people for the president-elect. The other 4 seats are unopposed. And so since they're unopposed, then they will go ahead and assume those positions there. We will need to have an election for the president-elect. We will need to do this because we have a virtual conference here. We obviously can't do paper ballot. We can't do anything like that we normally would do in the meeting. So we're going to have to do it by Mentimeter. And I will let Robbie Perkins explain again how that works and how we're going to do this election. Robbie, are you prepared for that, or do you need me to do some door prizes?
Let's have Rebecca do maybe a door prize and give me just a few minutes if you could, please.
Okay, because this was a nomination from the floor, then Robbie's going to have to put that together real quick. And so Rebecca, if you're still available, let's go ahead and draw another $25 Amazon gift card. If you're available.
Okay. I don't know how I can draw all this out, but so the winner of gift card number 3 is Miss Tanya Bradshaw with the Kentucky Department of Education. Just to let winners know, if your name is selected, I will be following up with you via email to obtain the address of where you would like your gift card to be sent. Thank you.
Okay, I do need to do one other thing real quick. So we had an additional nomination from the floor. Do I have a motion to close nominations?
Larry, this is Stan. I make a motion to close all nominations and to elect the 4 unopposed by acclamation.
Okay. Do we have a second to that motion?
I second Ronaldo Simmons.
Okay, so we have a motion and a second to close floor nominations and to accept the 4 unopposed. So without objection, that is so ordered. And so we will have an election here for president-elect. I will give Robbie another minute or 2 to get that in order. Rebecca, we have another gift card, $25 gift card.
Sure.
Okay. Everybody likes a prize, right?
The winner of the 4th gift card is Miss Christy Stivers with the Department of Juvenile Justice.
Department of Juvenile Justice, thank you. All right, congratulations, Christy, on that. And again, we'll give you these, we'll send these gift cards to your home address. One thing about the Mentimeter, Robbie's going to go over the specifics about how we're going to, how that operates. It's been a while since I've done that. The election is supposed to be for members only, so we'll have to obviously, through personal integrity, make sure that you're a member if you're voting on that. And Robbie, are you prepared, or do you need a little bit more time?
No, I'm ready to go. I have in the Q&A area of the platform, I have included an announcement. Go to www.menti.com. Use code 95381484. I'm about to share the Menti screen so everyone can see the results.
Larry, we did have a question about the door prizes.
Okay.
Do you want me to, it says, how do we get registered for the door prizes?
Yeah, so the door prizes were for paid chapter members only, because we didn't know this was open to the whole world. So we had no, since there was no registration, we couldn't collect any information as far as who was going to attend these meetings. So the door prizes that were given away are for paid chapter members only. Rebecca obviously has that list because she is the chapter treasurer, and so she is drawing the names, but that is how it is. There's no registration for that. By making this available to the public, we also eliminated the registration process. Okay. We're going to give a few minutes here to make sure everybody has a chance to vote. My computer screen is showing 12:17, and I will wait until 12:20 to make sure everybody has their chance to vote. So we'll continue with this process here. I will remind everyone again, I'm probably going to do it several times, that tomorrow we have 2 sessions. We have the morning, both of them in the morning, but we have session 1 and session 2. You will need to go to the agenda on our website for each session. So first thing in the morning, we will start with that first session. Then we'll take a break like we did today. Then you'll have to click out and go back into the second session in order to see that content. And tomorrow we have a very busy day, a lot of additional speakers, a lot of content built into one area there, and we will actually start a few minutes earlier tomorrow. We'll actually start at 8:45 tomorrow. Okay. My clock is showing 12:18, 12:19 now, so we'll give it to 12:20 for everyone to have a chance to vote. Okay, we do have somebody that just put something in the chat box. They don't know how to, the instructions to vote. Robbie had put that in there at 12:15. Menti.com, use the code, if you can see that up here in the Q&A box there.
Instructions are also on the screen there.
Okay, yes, at the top of the screen, yeah. Menti.com, use the code 9538-1484. Okay. All right, my clock now on my computer, my official work computer says 12:20. So we will close the election, and it looks like Mr. Grover Dale Clemens has been elected to be president-elect. So congratulations, Dale, and all the other members that were elected today. We will have, that was a very close election. We'll have Dale Clemens as president-elect, Rebecca Ogden as treasurer, Michelle Barnes as secretary, and Nitra Williams as member-at-large. Membership coordinator will be Tanya Lawrence, and of course, Renata Simmons will ascend to the president position. Okay, thank you, Robbie, for putting that together. That was on the fly there. We had a nomination from the floor there, and so obviously we didn't have Dale's picture on the nominees because it was a floor nomination. That's in accordance with the bylaws and Robert's Rules of Order. So next thing I have on the agenda is the Distinguished Service Award. Now, the Distinguished Service Award is an award that may be awarded annually by the Board of Directors. It doesn't have to be, but it's in the bylaws that we can do this. This is different from the Gaddis Award. The Gaddis Award is nominations come in, and we will actually be awarding that one tomorrow. The Distinguished Service Award is determined by the Board of Directors. Possible reasons for the nominations include the following: promotes and supports association functions, exhibits exceptional level of service to the chapter, excels beyond expectations of an association member, and who's an outstanding IPMA-HR role model. So those are some of the reasons why the board may choose someone to for this award. This year's recipient checks all those boxes. This year's recipient started their state government career in 2010 for the Department of Juvenile Justice. In 2011, this person moved to the Personnel Cabinet. It was around 2013 that this person came to me and asked me to mentor this person. We talked, and I gauged his sincerity, and I saw it, and so I agreed to be his mentor. And while still working for the Personnel Cabinet, he also started graduate school. He did his undergraduate work at EKU, also started graduate school at Kentucky State University, and graduated with his master's degree in 2015. At the Personnel Cabinet, he worked at first for Commissioner Bailey and later in the organizational management area. He then moved within the Personnel Cabinet to the technical side, working with Chris. He left the Personnel Cabinet in 2017 and went to the Legislative Research Commission in their payroll personnel area, and then came back to work in the executive branch in 2019. And he's now working as executive assistant in HR for the Tourism, Arts, and Heritage Cabinet. For IPMA-HR, the Kentucky chapter, we could quickly put him to work on the sponsorship committee, and he did an outstanding job. He accepted the role of president-elect in 2017 and served as president in 2018, 2019. He's always willing to do anything for the chapter. He conducted a session at one of our events a few years ago, providing insight into his time in the Middle East when he was in the Kentucky Army National Guard. And this is by total coincidence that he's just now been elected president-elect again. This year's winner of the Distinguished Service Award is Mr. Grover Dale Clemens. And Dale, and I'll say the same thing to the person tomorrow for the Gaddis Award. Normally, if we were in person, we would allow you to come up and say a few words. And for this particular presentation, you have to have a speaker's row. And so you don't have a speaker's row because that kind of maybe would have given it away a little bit. So what we agreed to do is for the two award winners, we're going to allow them to do a statement. So if you don't mind if you want to say some things to the chapter, if you will email me those comments, then when we do a follow-up email, we'll include those comments in that follow-up email. So congratulations to Mr. Grover Dale Clemens, this year's winner of the Distinguished Service Award. Okay, do we have any other, let's see, do we have any other comments here? I see some congratulations there. Do we have any other business to come before the board today? And you know how it works. So you have any questions and answers? Okay, I don't see any. So at this time, I will accept a motion to adjourn the business meeting.
So moved. This is Rebecca.
Rebecca's moved. Do we have a second?
Second.
This is Stan, second.
Second, third, okay. We have a motion and a second to adjourn the business meeting. So without objection, that is so ordered. Okay, so we are finished with the business meeting. The next thing I have is the closing statement for day one. Thank you for attending today. And you know, day one is concluded. We will start tomorrow, 15 minutes earlier, 8:45. We have a busy schedule tomorrow. Starting at 9 o'clock, Mr. Corey Hicks. Then we have some personnel cabinet for half an hour. We're going to have a 15-minute business meeting number 2, where we'll give out the Gaddis Award and a few little things. And then we're going to take a break. We're going to come back and do an HR panel, which is going to be timely and appropriate. I can't wait to hear the answers to some of the questions, which is going to be, you know, the aftermath, where we go now. We have three of the top HR people in state government, so that ought to be very interesting. Then we're going to go into Mr. Kareem Ellis, which we all enjoy. He's going to talk for half an hour to kind of end the session, and then we will adjourn after that. I want to remind everybody, first of all, for our sponsors, ServiceNow, they're the reason that we can have these events and the gift cards and different things to give away. Want to thank all the speakers this morning. Want to thank the board members for all the hard work that they put into this. Believe me, we had practice sessions and everything else, and just trying to make sure everything goes smoothly. And so far today, it looks like it has. Tomorrow, as I said many times already, We have the links that you have to click on in order to get to that particular session that you want to get to. And of course, later on, the links will turn to video. So if you miss something, you want to rewatch it, you can do that. One of the things I mentioned this morning, but I probably didn't do a real good job about it, was the credit through My Purpose. If you're, using a Kentucky ky.gov account, we will be able to see that, and we will be able to give you credit in My Purpose. For those that are not using the ky.gov account, you'll have to let your training coordinator know for them to manually enter it, or you can enter it yourself if you know how to do that. So we'll take care of it if you've gone through a Kentucky.gov account. Otherwise, we'll have to manually get that in there. So with that, board members, you all are on here. Did I miss anything that needs to be said before we conclude today?
We have one more door prize.
We have one more door prize. You're right, Rebecca. We have the big one for the day. We have the one-night stay at the Department of Parks. And first of all, I need to thank the Department of Parks and the Tourism, Arts, and Heritage Cabinet for donating these 2 one-night stays. Rebecca has those. We'll mail those to you. We got one today and one tomorrow. I think they're good for a year. I think they're good till like June of 2022. There are some limitations on the dates that you can go, but we have a wonderful Kentucky State Park system. And we were really hoping to get a couple of night stays to give to the chapter members. Everybody loves a $25 gift card, but everybody needs to get out and have fun. We've been cooped up for a year now. So Rebecca, we have that to give away. So do you have that available?
Yes. The winner of the first park gift certificate is Miss Tracy Hayden with the EEC cabinet.
All right, so Tracy Hayden with the Energy and Environment Cabinet. So she has won that Parks one-night stay. We'll get you that. We'll get that out there to you. With that, if there's no other business and everything is good, we were scheduled to go to 12:30. I'm showing 12:29. So everybody have a good day. Go get you some lunch. Get back to work a little bit, catch up a little bit, and we'll see you tomorrow morning at 8:45. Thanks.